We are in person in the Judge Joaquin V. Manibusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We're also live on the Judiciary's YouTube channel. As this meeting is being recorded, to avoid background noise, I ask the members appearing by Zoom to please mute yourselves unless you are specifically speaking. And if you are here in person, please wait until we position a microphone before you. All right, next issue, please put the next slide up. On agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices are included in your packet. All right, please move to agenda item 3, which is quorum. We'll start with the roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask the CLRC Administrative Assistant, Ms. Lisi Banis, to please call the roll.
Honorable Jonathan R. Kwan.
Present. Judiciary Wong.
Honorable Maria T. Senzon. Honorable Anita A. Sokola. Attorney William Bucky Brennan.
Update present for my office in Agania.
Director Fred Berdalio or his designee, Anton Uggan. Chief of Police Stephen Ignacio or his designee, Sergeant Michael Elliott.
Good afternoon, I'm present. I'm in Tizan, Guam.
Attorney Joseph B. McDonald.
Present from Sinahonya, Guam.
Attorney F. Randall Cunliffe.
Present from my office in Nigatya.
Mr. Monty McDowell.
Present. Judiciary Wong.
Public Defender Designee Attorney John Morrison.
Present from my office in Sinahonya, Guam.
Attorney General Designee Emily Reese.
Present from Tamuning.
Attorney Michael Phillips. Miss Valerie Regis. Attorney Christine Tenorio. Attorney Philip Tidinko. Ex officio members, Executive Director Serge Kenga. Compiler of laws, Jerry Cepeda. We have, Mr. Chairman, there are 8 commission members present.
Thank you. I ascertain that we have a quorum and can conduct the business of the commission this meeting. At this point, do we have anyone who needs to recognize? I'd like to recognize Justice Carvalito, Associate Justice Carvalito is present, as well as Christina Dare.
Thank you, Magistrate Kwan, and greetings to all of you.
All right. At this point, agenda item 4, we have the minutes of the May 29th, 2025 plenary meeting. These minutes were provided in the meeting packets for the members' review. May I have a motion to approve both minutes? I move it be approved as written. Second? Is there a second?
Second.
I second.
Thank you. Any opposed? At this point, the minutes of the May 29th meeting are hereby ending. Thank you, everyone. On agenda item 5, old business. Please put up slide 3. May I ask the executive director to provide the status update and report, please. Go ahead.
Thank you, Mr. Chairman. I have just a few informational items to report to the commission. The commission's interim report that was approved on May 29th at our plenary meeting was transmitted to the legislature on June 13th, as well as to the Chief Justice, the Governor, and other stakeholders. We are awaiting word from the legislature on when our recommendations will be introduced and considered by the legislature. Once that is done, we will report to the commission on whatever the legislature has planned for the interim report.
If I may, just to say briefly, that when we did provide it and we did get some informal feedback, they were very pleased with the work that was provided to them. Please, I'm sorry to interrupt.
The 2025 second quarter report of the commission was issued on July 11th and is available on our webpage for all to review. At this time, Mr. Chairman, I'd like to, please introduce our new research attorney. Attorney Andrew Street. Andrew, if you could, show yourself on our screen here. Thank you. Andrew is going to be, joining us remotely from, where he lives in, Japan. He recently passed the bar in Florida, I believe. He's a graduate of, Harvard Law School. Undergraduate from, UCLA, which, is okay as far as I'm concerned. Well, we're looking forward to having Andrew join the commission as a research attorney to assist in our research, whatever needs that members may have. I'll be meeting with him tomorrow, along with Gordon, just to show him the ropes and things that we do, get him started on what we need him to do. So welcome, Andrew. Thanks for being here. That's all I have to report, Mr. Chairman.
Thank you. To add on that to the commission members, the ex-official members and the subcommission chairs, we now have two very skilled and trained attorneys that can provide support in any fashion the subcommissions may need for research, for additional drafting and revision. So please, I encourage the subcommissions to utilize these very talented lawyers that have Mr. Anderson and Mr. Street, is that correct? Yeah, use these very talented attorneys to the fullest, so we can continue the work that we have done so well thus far. We can only multiply our efforts and our product so we can complete. With that being said, please move to slide 4. All right, continue to the next slide, new business. This is item agenda number 6. We will table the presentations of the subcommission on drugs and other criminal offenses, chaired by Judge Senzon, and the subcommission on crimes against persons until the next meeting. I ask the chairs of those subcommissions to be prepared to present at the next plenary meeting, please. I'd like to keep us along on a steady pace. So please, provide and prepare accordingly. That brings us to item 6C. Subcommission on Criminal Procedures continued discussions of a chapter previously presented. Mr. Executive Director, go ahead.
I'm sorry, Serge. We have Anton Uggan who just logged in, and we just want to make a note of that, the designee for DOC.
So we have 9.
Yes.
Major Uggan. Good afternoon, Major Uggan. Are you there? Major Anton Uggan, are you there? No, we can't count him. We can't count him unless he responds. Please continue, so.
Okay.
All right, thank you, Mr. Chair. On behalf of Judge Sokola, who is the chair of the Criminal Procedures Commission, and Attorney Emily Reeves.
Yes, sir, I'm here.
Okay, Major Uggan, are you standing in as a designee for Chief Bradalian?
Yes, he is.
Yes. All right, thank you. We have 9 officially. We now have 9. Good to hear from you, Major Uggan. Go ahead.
Okay, on behalf of our chair, Judge Sokola, and member attorney Emily Reeves from the Attorney General's office, I'm happy to present the recommendations of the subcommission on criminal procedure. Can you go to the next slide, please? So today, I will be presenting chapter 7, which is exemptions and defenses. Next slide, please. Today, we'll be focusing on articles 1, 2, and 3. I'd like to note that we did cover some of the content here in a previous plenary meeting. But since then, we've taken additional looks at the sections and made some tweaks and changes to some of the recommendations we previously made. And we'll also report on some of the sections that were not presented and maybe have were tabled at prior meetings. I'll note that, section 7.25 is being reviewed by Judge Senzon and her DOCO subcommission, along with, the mental health work team. So that is still pending. Articles 4 and 5 are also still pending. We decided after another look that we're gonna, take a deeper dive into these articles and report back to the commission at a later time.
And the black book.
Okay, so starting with, section 7.10, I'll go through these relatively quickly, since we did cover these, in a prior meeting. Just to show what we've done since then. So here in 7.10, there are changes that we're recommending to make this consistent with the Family Court Act 19 GCA, starting with section 5102. And, we're changing juvenile to minor, just so that it's consistent with the Family Court Act. No substantive changes here. Next slide, please. On section 7.16, defense, mental disease or defect, we have no changes to recommend. On 7.19, as we have done in the past, we're looking at the titles of the sections to make them more clear to the readers and users. So here, we're going to be getting rid of the recommending deletion of the word same and adding mental disease or defect so that it more clearly reflects the content in here. And I'd just like to note, I wondered why the original drafter used the word same in these. And when I pulled up the original criminal and correctional code from 1977, there's a table of contents, and it makes sense when you're looking at a table of contents, and maybe even an index to have it this way so that it's consistent there. But where we are at now, tables of contents are not necessary, as we can pull up a section. And it's actually easier to find when the content is stated in the title of the section. So again, it's a non-substantive amendment to the title. Next slide, please. Same thing here as in the previous slide, a non-substantive amendment to the title. Next slide, Jared. Here is 7.25. This was tabled last year. This will be reported on by DOCO and by Print Pro at a later time, so we'll just put this aside for now. 7.28, acquittal, order for civil commitment, no change. 7.31, a non-substantive amendment to the title for consistency and also for clarification. 7.34, so this was actually also tabled for discussion by DOCO and other subcommissions. So we will report back to the commission on this.
7.31, right?
4.
7.24, sorry. Okay, go ahead, Matt. Next one, 7.37.
7.37. Just a simple correction in subsection B, there was a missing D. Next slide. Here, another non-substantive amendment to the title. Next slide. 7.43, mental disease, again, non-substantive amendment to the title. And also for clarification on qualified psychiatrist, licensed psychologist, or other qualified person. So these changes will be consistent with the changes that will be recommended for 7.25. And we did discuss this with client services, and it's often the case that the psychologist there is called upon by the courts, and so this just makes it more clear. The amendment at the bottom paragraph there is just a clarification on the citation to HECA section 40.10.
Just a question on 7.43. The language, other qualified persons, that was, that's been vetted, that's not gonna cause a complication or difficulty.
That I think is actually in the current statute 7.25.
Okay, so we're consistent. Okay,
Right,
thank
it
you.
was consistent with that as well.
That.
Next slide, please. 7.46, another non-substantive amendment to the title. 7.49, again, another non-substantive amendment to the title. And also some clarifications on the citations. just to make it easier to read. Also non-substantive. Next, okay, so 7.52, no changes recommended for this section. Next slide. 7.55. Here we start in Article 3 defenses. So what we're doing here is we're going back to the model penal code. And we're looking at the substance of the section in the model penal code as well as its title. So for whatever reason, the drafters of the original criminal correctional code renamed the source model penal code section 2.04 is entitled ignorance or mistake. And I think it's a clarification for the section and makes it easier to read.
Just time.
Just the title, also a typo correction in subsection B to A. Adding a S to the end of the word act.
And we verified that the titles are not referenced, just as in the other statutes, just the section, the numbers.
Right.
Okay. Got it.
Next slide, please. 7.58 intoxication, no change recommended here. Next slide, please. 7.61 duress or necessity. Subsection A2. We are making this recommendation here. The original language was great bodily harm. So to make it consistent with other sections in this chapter, we're changing this to serious bodily injury. And as you'll see, as we get further along in this chapter, especially in 7.76, serious bodily injury, where you will be recommending the addition of a definition section to that.
Well, that's just in compliance with 1610. 1610.
Exactly, section 1610, where the actual definition of serious bodily injury is provided, and also for consistency across the chapter.
Homicide, aggravated assault.
Yeah. Next slide, please. So here, 7.64, again, going back to the source model penal code section, we'd like to rename this consent other than other defenses, which is what the drafters entitled this. It didn't really make much sense here, other defenses, without giving it any context. So again, it's consistent with the source model penal code section, which is 2.11.
Give me no floor.
Oh, bye.
Yeah, give me a second. I see. Okay, no, it's consistent. Got it. Thank you.
Next slide. Same thing here on 7.67. Renaming this de minimis infraction consists with the source model penal code section 2.12.
Just the title.
Just the title. And also getting back to what it was originally entitled in the model penal code. Next slide, please. Here again, for consistency, we're recommending this amendment to the title. Non-substantive change, just call it entrapment as it is in model penal code section 2.13.
Just title change.
Just title change, nothing else.
Yeah.
Next slide, please. So 7.73, again, recommending amendment to this title. The entire section addresses only renunciation. Not sure why all of these things were included in the title, but this will clarify and add context.
Just the title change.
Just title change, no other change. Oh, that's all we have then for chapter 7. Mr. Chair, we submit those recommendations for discussion.
Thank you. Thank you, Executive Director. I know the table is comprehensive. I know most of these are housekeeping or title changes. Is there any discussions on these recommendations concerning the chapter 7 proposals? These were included in the package prior to it. Yeah. Yes. Thank you.
Yes, yeah.
Is there any discussions? There being none, At this point, I'm gonna call for a motion, since there's no discussion, call for a motion to accept the subcommission, crypto subcommission's proposals. Is there a motion?
I'll make the motion.
Is there a second?
I second it.
Is there any opposition? Anybody opposed? There being none, subcommission, of criminal procedure subcommission's proposal, proposed amendments and no changes and actions are hereby approved and move to the final voting file. Thank you very much. Next slide, this is agenda item 4D. We have the first presentation of the ad hoc subcommission on corrections related chapters. This subcommission was specifically created to review a number of chapters that focus for the most part on corrections, disposition of offenders, sentencing, imprisonment, youth corrections, parole, probation, and so forth. Specifically, these subsections and provisions were taken out of DOCO, drugs and other offenses, and we have created the ad hoc subcommission to address it. I want to thank the members of the ad hoc subcommission for their hard work and diligence in agreeing to serve and to assist DOCO in the work they were assigned. That being said, Mr. Executive Director, please go ahead.
Thank you, Mr. Chairman. I'll report, it's my pleasure to report on behalf of the ad hoc subcommission. Here, can we go back just for a quick second? Yes, I'd like to recognize the members of the ad hoc subcommission. Attorney Christina Baird, Attorney Mary Hill is with the Public Defender's Office, Chief Parole Officer Mike Canata, Chief Probation Officer Roxville Vizgomez-Uggan, Probation Officer Supervisor Jeremiah Cruz, and we have two marshals, Kennedy Robinson and Dodd Mortera. All of these members of the ad hoc are volunteers. They're not official members of the commission. But like all the other members, they're both devoting their time, professional and personal time, to review the chapters and sections that concern them and provide their very meaningful feedback to us.
Please proceed.
Next slide, please. So today we'll be covering 9 GCA chapter 80, focusing on articles 1, 7, and 2. We've had 3 or 4 work sessions already, so we've done quite a bit of work on chapter 80. We started on chapter 80 with this ad hoc subcommission because it's really the most substantive and the longest chapter that will be reviewed by this subcommission. So it concerns corrections, parole, and probation, and a bunch of other things. And we'll go through articles 1 and 7. And then we do have a presentation on article 2 on a particular section that was found by the Guam Supreme Court to be unconstitutional. And Gordon Anderson will present some of the possible recommendations that may come out of ad hoc that we will present later to the commission for its consideration.
I'm jumping ahead, I know, I'm sorry to interrupt, but that's specifically involving Murtaugh, is that right?
Right, the Murtaugh decision out of the Supreme Court.
But it was never addressed statutorily.
Never,
Since the
not to
decision.
my knowledge, right. It hasn't been amended since then.
Okay, thank you.
Next slide, please. So starting with Article 1, we have no changes to recommend for these 3 sections. Sections 80.00, 80.16, and 80.22. If at any time any member wants to opine on any of these sections, we can try to pull it up and then we can talk about it. Remember the recommendations that we're submitting here are only the first round of recommendations. So we can always go back and take a harder look at these sections should any member, official member or volunteer member want to take a closer look at them. Next slide, please. So starting with section 80.10, we have a few amendments here, starting with subsection A, adding the word civilly just for clarification. And then making a few amendments to the subsections here, which are mostly typographical or grammatical. We've also recommended that for subsection 6 here, it be broken down into 2 other subsections, 7 and 8, for clarity. But this does not change the substance of this section or subsections. We have a typo corrected in subsection B. Highlighted are the sections that will be covered today by Gordon, whose constitutionality is questioned in the Supreme Court case we just mentioned. A correction in D, removing the brackets. And that will do for this section.
Just to verify, 7 and 8 are just a bifurcation of 6.
Yes, that is correct.
And we looked at, they were properly grouped, you said, they were properly grouped. Because it was and an or in that sentence. So it's or. Right,
They're also separate by semicolon.
Yeah.
So this is formatting.
that's correct. Okay, all right, thank you.
Next slide, please. 80.12 subsection A, just calling probation services by its official title. Subsection B, adding the word pre-sentence before report so that it's consistent with subsection A, the pre-sentence investigation and report. Same thing in subsection C. We're changing, and again in subsection C, changing commas to semicolons for consistency across the chapter. Next slide, please. Subsection, I'm sorry, 80.12 continued. D2, adding psychiatric observation or before examination, which is consistent with subsection D above there. The last part of the sentence in subsection D, to submit to psychiatric observation or examination. So it's just for consistency. And then in E1, typographical or grammatical correction. Department shall advise the court of its finding. Next slide, please. So here are the comments that are accompanying this section that we want to cover. I will note that this section 80.12 and the next section 80.14, I asked the Crim Pro subcommission to look at these sections for whether they would like to recommend moving these 2 sections into Title 8 because they do at least at first glance affect procedure rather than well, primarily procedure. So it might be better off in Title 8. And we've suggested here, perhaps in Chapter 120, Judgment and Sentence, has sections 120.24 and 120.25 respectively. We'll report back to the commission after Trimper has taken a closer look at this. But the recommendations will stand whether it's moved out or not.
Yeah, I'm sorry, excuse my ignorance, it's been a while since I've dealt with the mental health work. And evaluations, other than ordering them at the beginning. So when you're talking about the revisions in subsection E1, you're saying department. That's mental health or gibberish now. Is that right?
Paragraphs is Department of Court.
DOC, right? So
That's what it's a sub of. E,
Right.
Which refers
So-
to DOC.
it's DOC that's gonna provide a report, that provides the court its findings, and recommendations, hence the question. I don't think DOC does that.
That's in the, that wasn't, that's in the statute now,
Yeah.
right? So
So it's saying the department shall advise the court of its findings and recommendations on or before the experts to 90-day period. But the only department reference is
let's
DOC.
see what you.
The only one I know that does that, and it's been a while. And I think Mr. Cunliffe would know more, as well as Mr. Brennan, I know that does that would be Jibwick now, or, our own, psychiatric evaluation professional upstairs.
We talked about in subsection D, if we look at D delta.
Yeah.
Delta 1A refers to Jibwood. So E talks about other information in the court that DOC would have because he's confined at DOC.
So it's DOC that's providing that,
For information under subsection E,
E1,
yes.
Department of
Because
Corrections.
when you're talking about psychiatric eval,
Yep.
that's under subsection D delta,
Yes.
yes. E, Echo talks about additional information concerning an offender currently confined at DOC, so I think that's why the department.
The only,
sorted that info.
the only question I have is, I'm not familiar with, and I could be wrong, it's been a while. I'm not familiar with Department of Corrections providing the court any of its findings or recommendations ever.
If the court didn't desire it.
But I didn't know that they did that.
If the court desires additional information,
The department shall advise the court of its findings,
We can table this section
please.
and we'll take a harder look at this.
I think that might reference Jibwick. No, I don't know,
not the way the statute is set up, Jibwood.
Right.
And forensic information is under Delta.
Delta, right,
Yeah, and current confinement conditions and conduct is under Echo.
can I ask you, Jerome?
Sure.
Major Uggan. Major Uggan?
Yes, sure. Yes, sure.
In your recollection, has Department of Corrections ever issued any type of report to the court about any type of psychiatric issue?
We may have, Your Honor, in the past, when we had our own doctor in-house, Dr. Taminglo, Dr. Lighthizer, when they were in here on our own, within our organizational structure, but now we have Guam Behavioral that oversees everything, so all DOC does is just transport them to where they need to be, and let the provider provide those services, and any reports later don't come through DOC, usually goes from the provider straight to the court.
No, that makes sense. Okay, I understand now. I understand why the statute was created that way, so it's.
Yeah.
In the event they have an
In the event
in-house,
they do have one, okay, I got it.
which they're not precluded from in the future.
Okay.
Yeah.
Okay, so I don't think there's an issue.
So there's no inconsistency?
No, I think we're good.
Okay,
The DOC did do it in the past.
okay.
I don't want to preclude them from having the ability to do that in the future. Okay, thank you.
Okay, next slide, please, Jerry. Next slide. Okay, 80.14. Some recommendations, again, not substantive, at least in the first part, just to reorganize and renumber subsection A, so that it's a little easier to read. I think it actually goes back to how it was stated in the criminal correctional code. In subsection B, the ad hoc subcommission is recommending an increase from 2 to 5 days for the submission or the disclosure of the pre-sentence report. So this is a substantive change that the ad hoc subcommission is recommending. For discussion among commission members. Holding on to that just for a second, I'll show you some information in the comment. We'll go through this here. Adding pre-sentence report just for consistency and to shorten it, make it more clear, and then dropping to E, non-substantive change for clarification to to E. Renumbering as well. So getting back to whether the commission will approve the change from 2 to 5 days for disclosure of the pre-sentence report. Jerry, next slide, please. We have here examples from other jurisdictions. In the federal report, there is 35 days, requirement for 35 days unless the defendant waives. In the NMI, the report is to be made before imposition of sentence and disclosure to the defendants at a reasonable time before imposing sentence. California Penal Code, for a person convicted of a felony and eligible for probation, the report is to be made available at least 5 days or 9 days upon request of the defendant prior to the time fixed by the court for hearing. New Jersey doesn't have a specific time frame, simply saying pre-sentence investigation and report to the court before imposition of sentence or grant of probation. The New York criminal procedure law, again, even more general, not less than, more strict, not less than 1 court date before sentencing. So that's submitted to the commission members for discussion. Any thoughts on increasing it from 2 to 5 days? The disclosure of the pre-sentence report?
Normally, normally the sitting judge will provide well before, more than 5, usually more than 10, sometimes 30 days before the sentencing. And I do know that routinely they waive the pre-sentencing report on some cases. So I don't think that's a significant issue, unless the other criminal practitioners disagree.
Okay, I think we can move on then. Next slide, Kurt. 80.18, just a clarification in the citations, 80.83.15. 80.20, adding language here for clarification. That the court has to find the person to be a chronic alcoholic. I think it's implicit. I don't think there's not really a substantive change here. Next slide, please. Okay, so that will conclude our recommendations for Article 1. Moving to Article 7, hormone or anti-androgen pilot treatment program for convicted sex offenders. This is the chemical castration law enacted by the legislature in 2015. According to our chief probation officer, this program never got off the ground. No rules were ever enacted. It was just never enforced. Again, it was a pilot program that was set to expire 48 months after implementation. It was never implemented. It's been 10 years. Parole doesn't see that they will ever be able to get to this program. So they've recommended the complete repeal of this article. That's the recommendation we're submitting to the commission.
And the pilot was only supposed to last, what?
48 months
Yeah.
after implementation.
Yeah.
In 2015.
We're past the concept. Okay.
It was never implemented, so. Any questions or discussion on this? Next slide, here. Okay, so that concludes the recommendations that we have for Articles 1 and 7.
Okay, thank you, Mr. Executive Director. Is there any discussion in reference to Chapter 80 that was provided? Specifically Article 1 and then Article 7. Is there any discussion? Sorry?
He's going to present after this.
Okay, so at this point, if there's no discussions, I'd like to bring it before the commissioners. Is there a motion to approve the ad hoc subcommission's recommendations for chapter 80, articles 1 and article 7. So moved. Is there a second? Is there a second?
I'll second it.
Thank you. Any objections? There being none, it's moved to the final reading file. Thank you very much. For the members of the ad hoc subcommission, you've done excellent work. I want to thank you for once again agreeing to step forward and doing this, and I appreciate all your efforts. Let's move on to the next subject. To Executive Director.
All right, thank you, Mr. Chair, and members of the commission. At this time, I'd like to ask Gordon to present his research on IGCA section 80.3.
Good afternoon, everyone. This is a streamlined version of a PowerPoint that I've already presented to the ad hoc subcommittee and also to the CrimPro subcommittee 2 weeks ago. As Serge mentioned, the committee is still really early in the process of reviewing 9 GCA 8038 and 2 associated statutes. We're just sharing the short version with the Plenary Commission now to introduce the issue, put it on everyone's radar. So if anyone has any suggestions or input, please share them either during this meeting or afterwards. You can reach out to Serge or myself with any ideas you may have. Can we move to the next slide? So you can see that, sorry, can we go back one just to introduce it? So it's titled People v. Muratoc and the Extended Term Sentencing Statutes. I just want to make clear up front what I mean by extended term. I don't just mean a long term. It is a technical meaning of extended term, meaning a term of imprisonment that's longer than the normal maximum sentence under 9 GCA 8030. So just for example, under that statute, the normal maximum sentence for a third-degree felony would be 5 years of imprisonment. But what a court could do under section 8038 is it could impose a longer sentence. It could go over 5 years if it made certain findings. One of them would be that if the defendant has 2 or more previous felony convictions, then the court could exceed 5 years. And there's a couple of other findings too. So I do want to just make clear that when we're talking about extended term sentencing, we're talking about beyond the maximum. Next slide, please. So here's a quick overview. Starting as was mentioned before, section 8038 was held unconstitutional by the Guam Supreme Court in the Muratoc decision in 2003. There's a very specific defect in that statute that also appears to be in 9 GCA sections 8040 and 42. And I'll show you that in the next slide. But up front, the problem is the court making findings rather than the jury making findings that increase the sentence. So the question that was posed to us was, can these statutes be made constitutional? I believe the answer is yes. There's several ways we could go about doing that. And then at the end of this PowerPoint, I'll show you a couple of ideas that we've had so far. Next slide, please. So here's 8038. You see it's entitled Extended Term for Felonies, meaning beyond the normal maximum. This is a really long statute. Wouldn't have been able to fit it in a single slide, but the constitutional defect pops up in the very first sentence. Even before we get to all of the findings that a court would make, it starts by saying the court may sentence a person who's been convicted to an extended term of imprisonment if it finds one or more of the grounds specified in this section, meaning multiple felony offenses or some of the other things. But the key language is what's highlighted there, that an extended term might be imposed if the court makes the findings necessary to trigger the statute. Next slide, please. You can see this language, this if it finds language is actually directly out of the model penal code. Section 8038 isn't totally identical to Section 7, Model Penal Code Section 7.03, but this part is identical. The court may sentence a person if it finds. So the constitutional defect in our statute was latent all the way back to when the Model Penal Code was created. Next slide, please. And then here I showed the 2 other sections that I referenced, Section 8040 and 8042. These both also find that the court may extend a defendant's sentence if it finds, meaning if the court finds certain factors. Next slide, please. So we'll talk about Muratoc in just a moment, but to understand it, we need to start with Apprendi versus New Jersey. This was a really watershed United States Supreme Court decision from the year 2000. I've underlined here the key takeaway, which is the U.S. Supreme Court has said as a matter of constitutional law, other than the fact of a prior conviction, any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt. And then it goes on to say it's unconstitutional for a legislature essentially to create a statute where the court makes that finding rather than the jury. Next slide, please. So then 3 years after Apprendi, the Guam Supreme Court decided Muratoc, and you can see the Supreme Court thought this was essentially a straight application of the Apprendi doctrine that we just cited in the prior slide. It says an examination of the statutory language of Section 8038 says the court can sentence a defendant after the court itself makes various findings. The statute is unconstitutional and a violation of the Apprendi rule because it removes from the jury and prescribes to the court the duty to assess these facts. So that's the holding of Muratoc. The statute was invalidated by that decision. And so it's just been sitting there in our code since 2003. I don't believe it has been amended. It's just sitting there inoperative. Next slide, please. So when Serge and I started talking about how could we fix it, there's a couple ideas that came to mind. These are not the only possible approaches. These are just sort of the first three that I thought of. The first one is, could we just replace the court with the jury, right? If the problem is that the jury or the court makes findings rather than the jury, what if we just cross out it and write in the jury so that it reads, the court may sentence a person if the jury finds one or more of the grounds in this section. It's the upside of that would be very simple, brutally so. There are two potential downsides, I think. The first one is that, as near as I could tell, no other jurisdiction has done this. Since our statute comes from the Model Penal Code, like a lot of other jurisdictions, there's potentially been a lot of opportunities to make a substitution this simple, and nobody else has ever done it, as near as I can tell. That's not dispositive necessarily saying that the statute wouldn't work. We could be the only ones to do it, but it would be helpful, I think, if our statute was modeled on some other jurisdictions so that we could look at their court decisions and see how it's been interpreted after any sort of amendment. And the second problem, which is a little complicated and probably beyond the scope of this slide, but it is something that we're looking at closely, is whether this language would foreclose what's known as a Blakely waiver. That's named after another Supreme Court decision decided after Apprendi. The basic takeaway from Blakely is that a defendant can waive his Apprendi rights. In some situations, the defendant might rather have the court make the findings rather than the jury, which you're permitted to do as a matter of constitutional law. But if the statute just says the jury finds, then it's not clear to me that a defendant would be able to make a Blakely waiver. So we want to make sure that whatever change we make in order to fix one constitutional issue doesn't introduce a second one. So we're going to tread a little bit carefully with this idea. Next slide, please. Here's a one that's based on another jurisdiction. The idea here, the key takeaway, is that shifting the focus of the edit from who makes the finding to what the finding is. And so this is modeled on a Hawaii statute, which I've cited in the second paragraph down there. And so now if we followed this approach, it would say the court may sentence a person if it is proven beyond a reasonable doubt. And I think that language would be broad enough that it would encompass both submitted to the jury, but would also allow the defendant to stipulate to the facts in certain circumstances, or to ask the court to make the finding rather than the jury. And again, since this is coming from another jurisdiction, there's more research we can do to investigate whether this kind of language has been tested constitutionally in the Hawaii courts. And hopefully when we finish that research, we'll have a better idea of whether this can withstand scrutiny. Because again, we don't want to introduce a new constitutional problem while trying to fix the old one. And next slide, please. And then here's a third idea. You don't need to read too closely into this slide. It's just provided as an example. But one thing we could do is really overhaul the statute. I used Oregon as an example because I think this statute does a particularly good job of focusing on the procedural issues that I was talking about in the last two slides. You can see in 1A and B, this statute has been written in such a way to make it really clear that a defendant can either defer trial of the enhancement fact, meaning first they're tried for the offense they're on trial for, and then if they're found guilty, then there would be a second trial to determine whether the enhancement facts apply. It also explicitly makes it clear that the defendant can waive their rights, elect for it to be tried to the court, or just stipulate to it. I've found that a lot of jurisdictions have done something similar to this. There's not a lot of straight comparisons between Section 8038 and other jurisdictions. I bet there was in the past, shortly after the Model Penal Code was passed. But for any number of reasons, it looks like jurisdictions have started setting up more complicated, more specific statutes to address this issue. Next slide, please. So on that note, I've listed 7 jurisdictions that we've started looking at here. We have 3 jurisdictions at the top that have the if the court finds language similar to Guam. There's Florida, Missouri, and New Jersey. The New Jersey statute is a little bit different. New Jersey, of course, was where the Apprendi decision came from. And so they've amended the statute so it still provides if the court finds, but the kind of findings that trigger the statute are comply with Apprendi, where it says that there are certain things certain findings a court can make regarding prior convictions. And now the New Jersey statute only addresses that. So I don't think it poses a constitutional problem, but it's something to look at. The Florida and Missouri statutes look very similar to ours, and as near as I can tell, have not been struck down. I don't know if that's because state appellate courts haven't struck it down, or if it just hasn't made its way up to those courts yet. But in any case, those are 2 to look closely at because their statutes are comparatively similar to ours. Then there's 4 jurisdictions at the bottom, similar to the last slide. These are jurisdictions that had a statute, faced an Apprendi challenge shortly after 2000. The statute was found unconstitutional for the same reason as Apprendi. And thereafter, they amended the statute. That includes Oregon from the last slide, but also Illinois, Kansas, and Minnesota have pretty different statutory schemes after Apprendi. So if anyone is interested in contributing, we're still very early in the research. We're a ways away from making any recommendation, but if this is something anyone else wants to look at, here's a potential starting point of 7 jurisdictions to look at, and we'd love to have any input that anyone can provide. So thank you.
Thanks, Gordon. As Gordon has stated, reach out to us if you want to contribute to this discussion. If you have any preliminary ideas or any thoughts off the top of your heads based on your own experience with this, you can say them now, and we can take a deeper look at them when we meet in the work session with the ad hoc.
Is there any discussions or questions for Attorney Anderson? I have one. Sorry, Gordon. I have a question. The Hawaii statute,
Yes.
does Hawaii specifically, we using that statute, Hawaii allows the jury, well, mandates that the jury can find it beyond a reasonable doubt, or are we clear, or the court can do so if the defendant waives? It's clear in the statute and case law. Right, it's clear in the case law.
I don't believe it's clear in the statute, not to the extent that, for example, Oregon was. I do think it's clear in the case law, but I will have to look more closely at that before I can say authoritatively. I don't have a case I can cite offhand for that, but I do believe in preliminary research, that's how it has been interpreted.
Okay, well, that leaves it up to subject to interpretation by the Guam Supreme Court. I see. Okay, thank you. Thank you.
All right, if there's nothing else there, let's move to conclude the ad hoc presentation.
I want to thank the ad hoc commission members, as well as Attorney Anderson. We welcome Mr. Attorney Street. At this point, please go to the next slide. The next meeting, the plenary meeting is tentatively scheduled for Thursday, September 25th at noon. DOCO, the Judge Senzon, is scheduled to present, as well as persons and property subcommission. Should all be ready to present as well. Please move to the next slide. Agenda item 7, I have no new communications to present. Under agenda item 8, are there any comments from you?
Mr. Chairman, can I just make a few comments here?
Please, just.
I know it's already 1 o'clock and everyone here is extremely busy. But let me just add, if I may, that I just want to commend the efforts of everyone here who has participated and is participating in this endeavor. You know, when I first approached Surge a couple of years ago in reference to helping undertake this project, and ultimately, of course, Chairman Magistrate Kwan, we all realize the overwhelming effort that this will require. And I'm just heartened in reference to seeing how this is all being diligently pursued. And don't be disheartened if this takes some period of time. When I chaired updating 36 rules of appellate procedure more than 10, 15 years ago, we didn't have the tools that are now more readily available. We all appeared once a month in the Supreme Court courtroom. We flashed on the screen the Guam rules and the rules we were comparing it to. We had about 2 jurisdictions. And it took us 2 years to update 36 rules. When I discussed this with Search and we saw other jurisdictions that it took 5 to 10 years, hopefully it's not going to take that. But please be patient with everyone. This is a tremendous undertaking. When I approached Senator Frank Bloss, now Speaker Bloss, about helping fund and getting behind this undertaking, he said, so long as you can do it within 2 years. Well, Serge and I kind of swallowed and just said, we'll try. And we're still trying. So thank you all for your efforts. This will be a tremendous help, not only to the legal community, the courts of Guam, but the entire community of Guam. And so, Mr. Chairman and Serge and all the committee members, I just want to thank you for all your efforts. And I'm happy that I was able to observe what's going on, and I'm very encouraged that the task will be accomplished. So thank you for that. Thank you, Mr. Chairman.
Thank you, Justice Government. If there's no other comments from anyone, may I have a motion to adjourn?
So moved.
Second? Is there a second?
I'll second that.
Any objection? There being none, thank you all for your work. Appreciate it. Very successful meeting today. Thank you all.
Thank you.